skill level. Okay, thank you. Now, the intention is to raise the threshold from RQF level 3 to RQF level 6. That is the graduate level. RQF is just an abbreviation for Regulated Quality Framework. That is how they determine the level at which people are qualified. And the intention is to reduce the amount of low-key recruitment to the UK and to attract the best of talent and the best of workforce into the country. Now, this singular move, caused about over 180 occupations to be removed from the eligibility list, which means a lot of jobs that have been possible before have been eliminated. And this arrangement will prevent a lot of people from being able to come into the country like they did over the last 1 year. So, but in the meantime, while this is going on, there is a transitional arrangement which will allow some of these local skills to still be able to come to the country. There are going to be impact on major people. One, there will be impact on sponsors. There will be impact on the skilled workers, and there will be impact on their dependents. So I want to talk about the impact on sponsors. The sponsors from now going forward, every application that's called defined COS request submitted to the Home Office from 22nd of July going forward will not be granted. They will be rejected, and except they have been assigned before the 22nd of July. If they assign any of those defined means for those who wants to come into the country. If they assign it before the 22nd of July, the assignee is able to use it in the next 3 months. You can still use it in the period going forward 3 months from now. But if you didn't have it before 21st of July, then you cannot use it. And then any application that is made in that category will be rejected. But there will be transitional arrangement for overseas recruitment for those that have the COS before this deadline. And for any worker that is within the country that has been issued from 22nd July 2025, there's a need for the employer to state clearly that this is a transitional arrangement on the COS itself, and for that application to be valid. Otherwise, the Home Office will refuse them as invalid if they try to process it. So I'm going to move on quickly to the impact on care workers and senior care workers. Those are in the categories of the SOC 6135 and 6136. All overseas application in this category are closed from now henceforth. You can't do them again. This is because of the exploitation concerns. These are things that have happened over the last 1 year. All of us know the story, what was going on, and the Home Office decided to remain quiet for a long period of time, but they were working in the background. And the outcome of the decision is to close it down. But in the meantime, in-country switching will still be allowed. Workers who has been employed legally in care roles on or another visa for at least 3 months, because there's a bit of confusion that everybody thinks that they need to work 3 months before they can be issued a COS. No, if you are a care worker, hitherto that before now you have been working in the care sector, you don't need that 3 months qualification. But if you are not a care worker and you are working in other sectors and you want to cross over to care work, then you need the 3 months requirement before you can be legitimately issued with a COS. This provision is temporary. It's going to last until 22nd of July 2028. And again, that is subject to review. They are still going to be reviewing that. They won't make it permanent. They may come back tomorrow and say that it will stop in 2027. So everything is still possible. In-country extension is permitted. Workers who are last sponsored as skilled workers under SOC code 6135 and SOC code 6136 or their predecessors, SOCO 6145 and 6146, they are still permitted to be switching in country. They will they must have maintained a continuous skilled worker permission for that to be possible. There must be no gap. That is, you cannot stop in between and say, "Oh, I was doing something else," or you have breached what they call Section 39E, that is, overstaying in a way without any reasonable excuse. You will not be able to continue in that route. But if you have not broken that Section 39E, then you are permitted to come to switch in country. Then I want us to talk about further impact on sponsors. Sponsors must do a review, an internal review. They must look at the requirements of their employee and make sure they are in line, especially in terms of the salary threshold. The salary threshold must align with what the Home Office have recently put in place. You will know that there is a lot of changes in terms of salary threshold for all these categories of skilled worker. The major one being the salary threshold of general salary threshold for workers, skilled workers is 38,700, but it has been moved to 41,700. And going forward, any COS that is issued to any prospective employee, it must align with this new salary threshold. If it's not, then that application will be refused. And there are some categories that can benefit from a bit of discount, and those category are one, the new entrants. The new entrants are people who have just come into that line line or that career. The new entrants are people who are age age 26 or below. The new entrants are people who fall in those type of category, and they can be given a sort of discount. Then some of the people that are classed as new entrants are people who have a PhD qualification. And if you have a PhD qualification and you are in a specific role, maybe a researcher or somebody who is just newly graduated from the UK, you can be classed as a new entrant, and you can have a bit of discount of your salary threshold. And this is good news, because it means some people don't know that their age can help them to have a bit of discount, and they can get employment, more affordable employment. Because the reason why people don't want to issue COS, because the amount that the Home Office is requiring the employer to pay is steep. And if they ask you to pay 41,700 to somebody who's just newly come into a role in your organization, and you have to employ like 5 people, you know what? You do the maths. You know that's a bit steep on the part of the expenditure that the organization has to make. So the salary threshold vary from all these category. The skilled worker, the global business mobility, the scale up route, uh, uh, they don't have any transitional arrangement at all. It doesn't apply in those categories. It doesn't apply for the global business mobility. It doesn't apply for the scale up route. The salary threshold is so high. They say they are aligning in with the Office of National Statistics data, which means they go to HMRC to collect some information, and they come up with a figure. Some of them, you have to pay them as high as 50 something thousand pounds per annum. And this is why those category, if you want to go into them, you must need to do your research well, and the employer too must be able to. Some of them are without a job offer, so it's you that need to do the research and know how much you are going to meet in terms of salary. Um, Another point that I would like us to quickly look at is um, uh, um, temporary shortage list, separate shortage list that the Home Office will be creating. And the this temporary shortage list is time limited, according to the Home Office, and it gives access to some roles that are under the level RQF level 6 roles. and it runs alongside with the immigration salary list. You know, we have the immigration salary list where those occupations
Merci.
on that salary have a different kind of salary threshold and a more affordable salary threshold. They are now creating a time limited temporary shortage list, and this is not going to be to last forever. It will last until 2026. So if you have a role inside those salary temporary shortage list and immigration salary list, then you can still have a bit of a discount in terms of the salary threshold. Um, um, then another thing that the sponsors are meant to do if they are issuing the COS from 22nd of July, the COS form question we change to it will be asking them to tick to confirm if the job is on the current immigration salary list or temporary shortage list. You have to tick it, and otherwise the CS will be invalid. So these are some of the key things that we need to be expecting in the new changes. Another point I want to talk about very quickly is the change of the duration that you have to meet when you are trying to apply for settlement. This has changed from that 22nd of July to 10 years instead of the 5-year route. So except you have been on your sponsorship since the 11th of March 2024. You have to now comply with the new duration of 10-year ILR to settlement. The then another point is that from the 15th of July, the Home Office has done a major shift to e-visa, and the reason why they do this is to ensure there is a very more robust security into the UK to avoid illegal entrance into the UK. Which means from now on, we are not going to be using the biometric resident card, BRP again. We are going to move on to the e-visa, wherein you must update your passport all the time. You know, some people their passport will run out and they will keep it like that. You won't be able to travel because then your details, your information will not be correct, and you have to make sure that you are updating your e-visa with the correct information about yourself, and you are updating your passport and ensure that it's current. Otherwise, you'll be stopped at the border. And then through this e-visa, the landlords and employers are able to do online verification about an individual in the UK. So what they are trying to do is that they want to maintain a very strict immigration control in such a way that nobody can be slipping through the net. You can be checked at any time, and they can even find out where you are located. And this is very important for all of us to be aware of. So this deadline is very crucial for a lot of things, and we must all be prepared for what is coming. And in terms of action plan, I want us to all take note of this, that from this 22nd of July, jobs under uh, RQF level 6 are no longer viable. You need to have at least a qualification that is equivalent to a BSc in the UK for you to be recruited into the workforce of the United Kingdom. And if you are being offered a job role, ensure that your salary meets the newly revised threshold. Otherwise, that application will not see the light of the day. Then, in getting your certificate of sponsorship, you must be able to confirm this correctly. Otherwise, you won't. It will be a waste of time. And then prepare for the e-visa compliance, which will soon replace the physical documentation. There won't be any need for any physical documentation. It will be e-visa, and make sure your data or your information on that e-visa or your account is very, very correct or current. and then so that you can fit into this new framework. This adjustment is very, very key. Another point I'll quickly mention before I pause for a moment is the other areas that the Home Office and the government is investing a lot into is the global talent visa expansion. There will be a signal expansion in this category in order to attract the best of talent. What they are saying is that the strategy is that they want to turn the UK into an industrial hub, and as a result, they want people who are best talent in science, engineering, in culture, in art, and in those type of area to come into the country. They want professional who probably are leaders or potential leaders in their fields, or who have received one form of award in their field to come into the country, and as a result, the people who fall into this category can begin to prepare and begin to get themselves ready in order to take advantage of this requirement. It will benefit the migrant, and it will benefit the UK government. And that's what they say. They want this collaboration to take place and this partnership to take place because they believe this is the way forward for the UK government. They want to bring entrepreneurs and they want to bring researchers into the country. So if you are somebody in that category, you need to begin to prepare yourself. And what are the requirements? There's no need for a job offer. All you need to be doing is to show us that you have some form of recommendation or endorsement or a form of prize in that field to show that you are a leader or potential leader, or peer review or something that you have done like a research or recommendation to prove yourself in order to fit into that category. um, Once you can prove that, then you are qualified to make an application into that category. For employers, there's going to be a more strict compliance and sponsorship changes. There will be stricter regulation. Employers cannot pay their workers lower threshold, or they cannot afford not to keep adequate record. They must keep adequate and accurate record, or they will face a very steep penalty. And that's what the Home Office is planning right from 22nd of July. They have a way of doing these checks, and when they do their check and you are not complying as an employer, you will receive a penalty or a fine, and you will not be able to continue to sponsor because they will revoke that license. They want to ensure that the work you are offering meet the appropriate skill set and the salaries threshold. They must ensure that employee also meet new language requirement. They are carrying this language requirement far further. They want even the dependents, talking about the language requirement, which we extend to the families of the main applicant. The Home Office is now saying that there will be a sort of language requirement when they are making their application. So you must be aware of that when they make those demands, and be prepared for it. So there's one more point that I would like to mention, is in terms of the sponsorship of dependents and the sponsorship of your family when you try to apply for your visa. If you are given COS in the categories of 6135 and 6145, you will not be able to sponsor your immediate family from 22nd of July going forward, and except that you have been on the skilled worker healthcare visa before the 11th of March 2024. And this same thing applied to the predecessor sub code 61 45, or 61, 46. The only category that is able to do the extension for their family, if they are issued newly, will be 61, 31. But most employers don't issue this type of category, except you have a discussion around it with them. So I just want us to be aware of this. Um, for medium skill occupation, if the lead applicant had continuously had permission as a skilled worker, and accepting that there's no gap, section 39E gap, or except that it can, if it exists, it can be disregarded, then you are able to continue to extend your leave in this category. There are some exceptions that if you have those exceptions, you can be able to come to extend your leave with your family. And I will quickly run through the exceptions that have been identified even by the Home Office. If you are a migrant and you have been sponsored as a care worker with your partner since before 11th of March 2024, you can continue to apply as such. If you are a care worker who have been applying since 2023, but you have not applied with your partner before, you can make an application for your dependent to join you. You can still make an application for your dependent to join you at any time, which means you have existed pre that March 11, 2024. You can continue to apply as such. And there are still other categories that can continue to apply as well. For instance, they gave an example, a scenario of a migrant who is trying to switch from being a care worker on sometimes around October 2024. If their children are applying for the same permission or were born in the UK, they can make an application. They will be able to apply for extension of their visa. Now, I want to point to the children that are born in the UK. They cannot be limited by all these family rules that they cannot extend, because they were born here, and as such, they can continue to apply with their parents. And if a parent is the sole surviving parent, and they are in this category, regardless of their situation, and they have sole responsibility for these children, they can continue to apply with their main sponsor or their sole parent in that category. So I just want us to absorb what I've been talking about and process it. And if you have any question or any area that you wish to me to clarify, I will be more than willing to do that as soon as I have your question. Thank you. Yeah. Over to you, Toladi.
Yeah, thank you so much, Mr. Olu. And we apologize for the archives that came into our system. This would not repeat itself.
Thank you.
Okay, going forward, if you have any question, please drop it. You could send it to Alpha Shindaro, anonymously if you don't want to drop it on the chat. Also, Mr. Eric would be taking us on what are the things that you should be doing right now, how to proceed, how to get ahead, not get ahead of the law, but what are the necessary things or necessary steps that you need to proceed in. Mr. Eric.
Well, thank you very much, Tolade. To be fair, my director Olu has spoken about many of the things I was going to talk about. A very common question that has come to us recently since the advent of the new rules and indeed the immigration white paper sometime in May, A very common question that's been coming in. Are people that are stuck as care workers under the 6135 or 6136 COS code or SOC code? And, there's cases where people maybe have children in the country, and then you can easily make an application. And then in those circumstances, the Home Office will need to consider what is in the best interest of the child, and then grant the family together as dependents of the main skilled worker. But there's also cases where people are not so lucky. Maybe they've not had the opportunity to have children at that time, and it's just maybe a wife and a child. Maybe in circumstances, for example, where people came in as students in 2022 and they've exhausted the period of stay as students. They've gone on to the postgraduate, and now one spouse is now a carer under 6135 or 6136, and now they don't have kids, obviously, and the rules don't allow the dependents to join the skilled worker because of the limitations being on a 6135 or 6136 COS. We've got questions about what can I do in this circumstance. Clearly, the rules don't allow that sort of application. And in any case where such person makes an application as a dependent, because they're going to fall for eligibility, they will not be granted that visa. But what is usually available to those sort of people or persons in that circumstance is applying outside of the rules, because clearly you can't do that sort of thing applying under Appendix SW. So you find that right now, under the current regime, in the current climate that we have going on, given the advent of the new rules, you want to always seek legal advice, because in circumstances where you're applying outside of the rules is a much more complicated case. It's possible there's scope for making, for example, an Article 8 application, but because every case is different, sometimes you see things going around on social media, people saying, oh, they did this and they did that, and the next person thinks, oh, because my friend did that, I should be able to do it as well. But in most cases, you find that people who adopt that one-size-fits-all approach, especially in immigration cases, don't end up successful. But in terms of answering the question, is there something you could do? Is there recourse available at law? The answer is very much yes, despite the fact that maybe because of your circumstances, you've not been able to clearly activate your family right by having children in the UK, and you're not eligible for a 6135, 6136 visa. There's still scope to make an application as a dependent. But should you do that in the normal way under the Appendix SW rules, you are not going to be granted that visa. So, under the current regime, there's instructions for or points to note for either a person as an individual, just going through the current regime, or a business wanting to maybe a care business or restaurant business owner, whatever. You want to employ immigrants and you want to sponsor them. Obviously, there's certain things you want to be mindful of. A big change that has just come in, given the current rules, the issue of salary thresholds. There's a question of, if you were employed and sponsored as a skilled worker before April 2024, how much salary do you need to be earning to meet the salary threshold? If you were employed after April 2024 but before July 2025, how much do you need to be earning? If you're being employed and sponsored after July 22nd of July 2025, how much do you need to be earning? And it's a very much complicated question, I promise you. And the reason is very simple. Now, under the immigration rules, there's generally, specifically Appendix skilled worker of the immigration rules, there's 3 general requirements that every applicant must meet. The first is eligibility requirements. The second is suitability requirements and validity requirements. Now, most of the changes have been brought under eligibility requirements. So generally speaking, when every application is considered, whether a person is eligible for a skilled worker application, for example, I think my colleague, my director Olu, touched on this earlier as well. you're going to be awarded 50 points in all things being equal. So the first question is, do you meet the language requirements? If you do, you're going to be awarded 10 points. Do you meet, do you have a job at an appropriate skill level? If you do, you're going to be awarded 20 points. That's when the question of, is it a job within the RQF 6 or above? But where the major change or the most confusing change has come up is whether you meet the appropriate sponsorship. And in terms of answering the question whether you're rightly sponsored or not, there's various considerations. The considerations such as salary. Do you meet the salary threshold? There's considerations such as what job you're doing. Are you doing a role that you're actually eligible or competent to offer? So generally, I think if you find on the immigration rules, you'll see a salary table, which is something that was very confusing to people. Well, two salary tables. There's table 1 to table 3 AA, I believe. And there's also options between options A to option K. So, and a very common question that you also find is, as a care worker, are you able to, what salary do you need to be earning? So we'll take the care worker part, but because there's various other occupations, in order to properly assess whether the salary you're earning currently is what you need to be earning for a future visa application, that's something that would need a proper nuanced advice, and you need to be specific in answering that question. But answering the care question, the general answer is people currently employed as skilled worker within the 6135 or 6136 code can still qualify for sponsorship as long as they're earning £25,000 yearly, or 12, I think is 12.82 per hour. So I hope that answers that question. But in any case, any circumstance, because you need to know that from yesterday or 2 days ago, the 22nd of July, the new rules came into force. So there's now strict interpretation. There's no transitional arrangements whatsoever for as far as salary thresholds go. So if, for example, you were first employed or employed and sponsored as a skilled worker in 2023, and say, for example, at that time, the threshold was £26,000, but it came, and you were then earning £26,000. If you're now making an extension of your former visa, there's a question of, well, do you need to be earning that same 26, or will you meet the threshold if you're still earning that 26,000? Another very common question is, if you were sponsored, for example, in May last year, as many people were, and at that time, perhaps the threshold was at 38,700 and your salary was 39,000, for example. If you then need to make an extension application in 2026 or later this year, do you still need to be earning that same amount? But the answer is no, because there's no transitional arrangements. The only transitional arrangements that exist as far as salary thresholds go for skilled worker applications are applications that, or people that were sponsored before April of 2024. So as long as you were sponsored after April 2024 and before July 2025, 22nd of July 2025, in any event that you're making a future application, an extension, a new application, whatever, you must meet these new salary thresholds regardless of what you were earning before. And the new salary threshold, as a general rule, is either the going rate for your occupation or the general threshold of 41,700, whichever is higher. Of course, there's an exception for occupations under the immigration salary list, as my director said earlier. There's examples of occupations under the ISL, occupations like care, specifically code 6135 and 6136. However, it's very important to note that the immigration salary list is only going to be live until I think December next year. So after December next year, the Home Office intends to scrap the immigration salary list, which will then have the effect of rendering occupations like care, particularly code 6135 and 6136, outside of the immigration salary list, which will then mean that you no longer have the benefit of being sponsored if you're earning about £25,000 or £33,000. Yes, so I think that's about it for me at this stage. We'll take any questions, as my colleague said earlier. Thank you very much.
Thank you so much, Eric. Mr. Olu, do you have any other thing to say? We have some
Yes.
questions, but I will.
Okay, you have questions.
Yes. So I think okay.
I just want to talk briefly about care workers
Okay.
who had been displaced. These are people who are most worried and who have a reason to be thinking, what do we do? There are some care workers who have been displaced, and because their sponsors had their license revoked, or their sponsors did not provide work for them, thereby making them to be displaced without work. So this set of people will be able to switch in country, because that's the provision of these new rules. They're able to switch in country to a new employer, and if they find a new employer, the Home Office has allowed that they will be able to switch, and they can follow the pathway to the 5-year ILR. That still remain intact, because they are not changing their timeline to settlement, because they were only unfortunate not to have been able to have a good employer. So this is one point that I would like us to take note of. And my word to them is that they should continue to look for a new sponsor as much as possible. And when they find a new sponsor, they can switch and they can begin to follow the original timeline. Thank you very much.
If you have any other question, please drop it. Winnie asked, for someone planning to extend, I think that Eric has answered this, but I would still read it out. For anyone planning to extend their visa on their current COS, would their salary threshold apply? Would the new salary threshold apply? I think Eric had answered this, but I don't know if you still
just to touch on that again, yeah, I actually did speak about that in some detail, but just like I was saying, there's no one size fits all approach or answer to that question. The answer will very much be dependent on questions such as, first, when were you sponsored? In circumstances where you were sponsored prior to the 4th of April 2024, it's possible that the transitional arrangements that were in place at that time will see you even to now, in which case you can continue to have the salary threshold that you did at that time. If you were first sponsored prior to April 2020, after April 2024, but before the 22nd of July 2025, then it's very likely, or I think the question is very much that no, you will not be able to rely on your former salary threshold. In future applications, such as an extension, you will need to meet the new requirements, the new salary threshold. But that's not the only question in that you will need to ask yourself when you're making the determination. You also need to ask yourself questions such as what industry are you working in? What table does your occupation fall under the new rules? There's a lot of questions. So there's very much not a one size fits all approach. What I will say is, before you make any applications, you want to actually speak with immigration experts and immigration solicitor and immigration advisor, what have you, available to you. You want to speak to somebody and get actual advice to see if maybe there's something you need to do, change employers or anything like that, before you have certainty that you are likely to meet the eligibility requirements for that role. Yeah, that's everything. Thank you.
Okay. All right. Thank you so much, Eric. Someone else asked, can you please clarify the new Adeswa, asked, can you please clarify the new ILR ILR rules.
Okay. Can I take that? The new ILR rules stipulates that for those who are being sponsored from the 22nd of July 2025, the new rule takes you to 10 years. It used to be 5 years. For those who came in pre 2020, 22nd of July 2025, they will still follow the 5 year route to ILR. And that's the general rule for that. But I want to mention that there is a faster ILR available for NHS workers, even from the 22nd of July. If you work for the NHS, you are treated differently. You are favored more than anyone else. And if your spouse, by any chance, is a British citizen, you still follow the 5 year route. They have not changed that. They chose to leave that intact. So take note of those two conditions. But for those that are just going to be sponsored from the 22nd of July going forward, they are going to follow the 10-year pathway to ILR. That's very key. So I hope that answers your question.
Yeah, if I may add one or two things to that as well, it's very important to note that I mean, one thing we've definitely seen is in terms of pathways, immigration rules are very volatile, right? The other day on Twitter, for example, I had somebody asking me what happens if I think the person was due ILR under the current rules sometime in 2030, and the person was asking me in 2025. So the immigration rules is very volatile. It changes. You can't. I think you want to take anything anybody says well in advance of when you're actually due with a pinch of salt, because it's very possible that things change in the future. And the Home Office has actually promised in the rules that came out 2 days ago that there's going to be new rules in relation to ILR. So there's not much that has been introduced so far, but toward the end of this year, I think in November or December, there's going to be very massive clarity in terms of because now they've said, oh, there's going to be 10-year routes, just like my director has said. But in qualifying the 10-year route, some people might qualify for to qualify for ILR faster than others, just like my director has said, like NHS workers, for example. But there's going to be more clarity given by the Home Office in new directions, new rules that will come out later this year. So I think what we want to do at the moment is just keep our fingers crossed and our eyes peeled. Thank you.
Thank you very much. I just want to quickly add something that I must have skipped. That's the skilled workers side jobs. You see, if you come under the category of skilled workers, you are entitled to have 20 hours extra work per week in any job. You see, but I want to put a caveat. You must keep strictly to this rule. If you work more than 20 hours, you'll be surprised. When you get to your renewal, the Home Office will pounce on you, and they will begin to apply some strict requirement that why did you work more than 20 hours? You must follow this visa rule, because I've seen cases where because of doing more than that 20 hours, the Home Office refused, and they were adamant that they were not going to allow that person to extend their visa in the UK, and it was not a very good experience, and they had to go back to their country. I don't want anybody to fall into that situation. So if you are doing extra hours, except you will seek an additional COS from the new employer giving you more than 20 hours. If you don't, there is a danger that when you come to renewal, you have a big question to answer. Thank you.
Okay, thank you so much, Mr. Olu. So someone sent me a message or a question. If I'm already overstaying and undocumented but married to someone with legal status, can I come forward without risking removal?
Okay, you want me to take that question?
Yes, please.
Okay, my best advice for you is that you need to come forward. You see, what most people do is to go and hide. Play the ostrich game. You know, you bury their head in the sand, and then the whole body is very visible. This UK, you know, I just told you about e-visa. Everything is going to be very visible. You know, if you come across the authority anywhere, it's just a simple tap on their phone, and they will see everything about you. So the best advice is that you should come forward. You don't need to hide. You need to come forward and need to present your case. If you come forward, then an advisor who knows their business, they will be able to advise you on how to proceed and give you the relevant protection using the law. And by so doing, you get faster to your destination rather than continue to hide. And this can cause a big problem. So, advice, come forward and discuss your matter as soon as possible.
Thank you so much. Someone asked the question regarding the skilled worker 20 hours. 20 hours work, can it be a business? And how can you show that you are not spending more than 20 hours on the business? Do you understand the question?
Let them. The question, the way I understand it, is that they want to start a business and then do more than 20 hours in that business.
Right. So, regarding the skilled worker, I think that no, not that they want to do 20 hours. I think that they want to start a business, but they want to be sure that, or they want to do 20 hours on the business. But how can you now prove that it's 20 hours? Like,
Now, this is a very tricky question. Let me just make this clear. You know, for people who are skilled worker, they are not entitled to even start a business to start with. You understand? The Home Office has a requirement that you cannot go and start a business while you are being sponsored as a skilled worker. So it's a red line which you must tread cautiously. So if you are now going to now tell the Home Office that I've broken your rule, or I want to use it to comply with your 20 hour, then you are going to hand them the evidence with you to prosecute you. So don't do that, because it's a no-go area. So it's better you follow the rules. You know, I made this bold because don't break this rule. I had my clients who had this problem of breaching the 20 hours rule, and when they come to renewal, they got good sponsorship from a good employer who is going to pay them a lot of money. But Home Office said, because you broke the 20 hours rule, we are not going to let you. So it's something that you must follow strictly. Proving it with your own business is a red line.
okay, thank you very much, sir. One question: can someone challenge the new income threshold for family visa on the basis of disability or long-term illness that prevents working full-time?
Yes, family threshold. You know, this is one of the areas that the Home Office have put on suspension. The Tory government, when they were in power, they tried to move it to £38,000, as if love depend on money. You know, because they are requiring people to have £38,000 before they can marry their wife, or before they can have children and stuff like that. But you know, the Labour government is very, very careful about this. They are treading very cautiously. They have put it on hold. It's still the 29,000, and they have not decided. They said some people should be carrying out a sort of research about where they are going to place that. Combined income of both will be that. But to your question, which talks about disability, disability is one of the exemption that you can have to avoid the 29,000 requirement. If you have disability, but you must be able to prove it. You must show that you have evidence of this disability, And if you have the evidence of disability, then you don't need to meet that requirement. All you need to do is to provide evidence of Department of Work and Pension or payment of your PIP or evidence that you have this disability. So you don't need to really have meet that 29,000 requirement. That's an area where you can have some exemption. Yeah, so you can challenge it with disability.
Okay. We have some more questions, but I will take just two more. Are there any legal routes single mothers with no status who have children born in the UK, especially if their father are absent? I don't know if you understand the question, sir.
They have their the children are born in the UK. Is that what they're saying? And the father is absent, but his children are. What's the status of the children?
The children born in the UK, I don't know the status of the children. So maybe we should answer if the children have like their legal stay here, and if they were just born here and they haven't used a number of years expected, I guess.
Yes. If you are a single mother and you have your child born in the UK, and the child is been living in the UK on a continuous basis for at least a period of 7 years, there's a route for them to go to apply for further leave, and on that same basis, the mother can depend on that child to apply for their own leave. But the conditions are these: you must show that it's undesirable to exclude such children from the UK. That is, their future lies here. Maybe they have been going to school in active education, and if you exclude them, then you disrupt them. In fact, the Home Office is willing to go a little bit lower than even 7 years. If the situation ever arose, they were touting about 5 years requirement where you can actually submit something for those children. And if that child succeed, then you as a parent, you can depend on that child. More so when the father is not even absent, then it means you have sole parental responsibility for such a child. It would be wrong for the child to be here and the mother to be removed. So that is a possibility, and the Home Office, under the residual human rights laws, you can be able to succeed and make a case for yourself.
Okay, thank you so much. I will take one last question. If you have any other question, you could just drop it, and probably just drop your email address if you did not register for the webinar, and we would answer the questions in your email. So this question says, if someone who used fake documents to enter the UK years ago, but has built a stable life here, is it ever possible to regularize their stay, or is it game over?
Yeah, that's a very dangerous move. When Home Office is very sometimes I even see the Home Office as very lenient, but when it comes to using fake document, or they call it deception, or when you use those type of things, the Home Office is very robust about their response. Number one, what they try to do is to ban the individual. They ban the individual, and the ban is always very stiff. They can go as high as 10 years. They will do a 10-year ban on the person, and they will suggest that they're going to deport them. They will start a deportation proceeding, and on the basis that the person have used deception, and they have shown lack of respect for the UK immigration rule. But you see, if that happens, and you see, the Home Office sometimes they look at other considerations. For instance, if that individual has got a family here, if they've got like children who are requiring their presence here, or children who depend on them for in order to do whatever activities they are into on a day-to-day basis, and on the basis of human rights, there can still be some arguments for leniency, and for argument for the Home Office to show some compassion. But the Home Office is always very reluctant, and they use all their best endeavor to tackle such individuals. So my suggestion to such an individual is to seek appropriate advice on how to proceed if they have not already started a deportation proceeding or trying to remove the person administratively from the UK. So it's what contending if you're in that situation. Yeah. There's something that I want to quickly drop in also for our listener this evening, and it's about the graduate visa. We are going to have what we call the shorter duration. It was 2 years. It's going to be 18 months from the 22nd going forward. But if you graduated before the 22nd of July, you may still get the 2 years. My advice is that you must quickly submit your application. Don't waste time before they change their mind. So if you are in that category, quickly submit your application, because they are thinking of how to reduce everything and how to change everybody if do what you need to do as soon as possible if you finish your education before 22nd. Yeah.
Thank you so much. I am so sorry, but is it possible to take 2 more questions? Specific speaking, I'm done with my.
Go on. Well,
okay, I'm done with my program next year. I think Mr. Olu actually just touched on this. And my visa, I'm done with my program next year, and my student visa expires in January. I work the 40 hours from next month or not? Can I work the 40 hours from next month or not? So I'm done with my program, maybe school next month, and my student visa expires in January next year. And can I work the 40 hours from next month or not? So she's asking that how. Okay, do you understand the question, Mr. Olu?
You are no longer in term times. Is that what you are saying?
Yeah, she's no longer in school. So can she start working 40 hours from next month?
Yeah, the full time. Yeah, you can start working from next month because you have already finished your studies. But my advice to you, just that question on the graduate visa, if you have that opportunity, take it before they change their mind. So you can, if you finish before the 22nd, you are still eligible for the 2 years. What they are trying to do, the new rules, they want to block a lot of people from having what they desire, and they want to increase a lot of things. For instance, by December 2025, they are going to increase the IHS, that is the immigration health surcharge for all migrants. That is the money you pay in order to access the NHS services. They want to increase that money because they think that the NHS is facing a lot of expenditure that they need not to face, and they want to generate money for them. So they are, the money is already high. The threshold is very high. It's 2,570 or something like that, and they want to increase that for your information. So if you need to do anything, do it as soon as possible.
Okay, thank you so much, Mr. Olu. One last question. This person says that she is working, but she doesn't have sponsorship. She doesn't have, she's on post-study, right? And the new law is taking place this month. What does she do? How can she prepare herself, or sorry, how can they prepare themselves really for, the
She's
new
it,
law.
oh, they've done is done with studying
Yeah, so they are on post-study.
on post study. Okay, so I just want to know, because I don't know the full circumstances of that individual. You know, there are so many um, um, things that people can actually be exploring while they are in that situation. If they are single, I don't know, because some people they try to hide their relationship as well. If they have a partner or somebody they've been moving with, or they are prospecting, they need to consider everything. If you have a partner, you need to consider that aspect as well. You don't need to marry them before you can start to talk about working out your immigration plans with them. And then if your age fall, I was talking about new entrants under the skill worker category. There's a lot of prospects in that area. I don't know if your age below under 26. You see, this one of your negotiation points with an employer, because you can negotiate how much you get paid. And why the employer don't want some people is because they say, I'm not able to afford paying these people. But if you can negotiate with your age, they can consider you. If you are in the category, maybe you have a postdoctoral researcher qualification, you have a PhD, that's the meaning of that. You can, or you are working towards the qualification, and you have spent some time on your research. You can use that as a ground to negotiate your wages as well. You can begin to consider other things like this issue about global talent. If you have some qualification in that aspect, I don't know what you have studied. If you have some talent, the entire UK government and the organization and companies, they are trying to attract and retain highly skilled individuals from around the world. So you may fall into this category. Is worth exploring. And if you can have some endorsement or some peer review or things that can let employers consider you, you should look into that as well. And also, because you are on post study, there's a prospect for you if you now want to start a business, and you want to start a business with the ultimate aim of sponsoring yourself at a later date. This is a time for you to look into all of those. And see, while you are exploring, don't leave behind the point of looking for a new sponsor. And along the line, I know something will work out if you don't relent. Thank you.
Okay, thank you so much. So that will be all for now for all the questions. Any other question we will send to your email if you drop your email. Before we go, once again, thank you so much. If you found this really helpful and you need personal support with your immigration case, you need to maybe ask for further advice. If you need more clarity, you could book us a consultation. I will drop our website on the chat so you could reach out to us, right? Also, we'll be sending you a link after this session, maybe tomorrow, as regards to like this webinar. Hopefully they're able to scrap out the part where ACAs were in. Then also we'll send you the link. We'll send you all our social media platforms where you could reach us via. Whether you're planning, to switch your visa, you're facing delay, or you're very unsure of your next step, you do not have to do this alone. We are here to guide you. And once again, this session is recorded, so you would get it in your email, as said before, as a replay. Thank you so much. And from all of us at Alpha Shindara Legal, thank you for trusting us, and have a lovely evening.
Thank you very much, Ladi.
Yeah.
Very grateful. Thank you. let me call you back. I just